But the law also has got an internal component for that matter. And that is, what is actually internal component of matter? Fairness of law. The law also has got certain kind of, it has got certain moral content for that matter. The moral content should be preserved. So whenever a new sector comes up, whenever a new regulation comes up, the lawyers have got a responsibility to make sure that these principles actually are done in alignment with the principles of morality, the principles of equity for that matter, social inclusion for that matter. So these are very important, in terms of making the globalization just, fair, and inclusive. So I'll stop here. Thank you.
Thank you, Professor Dr. James. That was quite enlightened views. Thank you. Now, Dr. Sayan, your views, please.
To all of you, let me go lighter on the term globalization, right? Now, globalization, then a new term came, deglobalization, then a new term came, neo-globalization, and in 1940s, the term came Re-Globalization. But in a lighter note, because I'm a teacher, and I go light with my students so that they can understand. Globalization, I would rather simplify as opening the doors, right? Opening the doors in what sense? Let me take example of mine. I am born a Shudra, as per the Hindu casteism that is followed. But right now, as a teacher, I am doing a work of a Brahmin. So these very doors are open. A good friend of mine who is a Brahmin, right now is having a boutique salon and spa. So that point of time, if you see, the doors are open. But literally in legal profession, whether the doors in the globalization era, or even if we are saying about Re-Globalization, whether the Advocates Act of 1961 can visualize or has the vision to incorporate all such terminologies. If I go with section 24 of the Advocates Act 1961, it's precisely under clause 1, 3, 4, which is substituted in 1974 or 1964. In any other case, who will be enrolled and who can practice actually? In any other case from any university outside the territory of India, if the degree is recognized for the purposes of this act by the Bar Council of India. So that means that only if the BCI allows, and that point of time you are going global, you are coming back, that point of time whether you can enroll yourself. Now this is a challenge. And I thought in a global world, when we are globally working with various aspects, you all know about LPU, legal process outsourcing. Company like Pangia 3, company like United Lakes, you are all learning the laws of other countries, working over there as an intern or working anywhere or in these LPUs. But sincerely, there were some students of mine who were from Zimbabwe, about 18 students. Across India, wherever the Zimbabwean students have studied, they were facing some challenges. And whatever the challenge, they can't practice in their country after studying in India. The reason? Because in their higher education department, only one institute is recognized. And this was, I think, it was Oro or Nirma University, which was recognized by them. And Sharda University, the NCR, Galgotia, none are recognized. So what they felt of doing masters, and they can go over there and they can actually be an academician, but rather they can't represent themselves in the court of law. Now, if it is this scenario to this legal profession, be it you being a citizen of India, going abroad, like my one student is right now after LLM in Queen's Mary, want to practice, but he need to crack certain kind of examination. So, going global the trade laws, the business, Apple coming in India, we are thinking that the mobile rates and all such devices will come down. But challenges will really come. But whether the Indian laws are accepting these or not, these are the challenges. And look forward to how the legislatures and as well as the judiciary will look into those concerns. Thank you.
Thank you, Dr. Sayan. Quite a different views where you can get more insight into globalization, deglobalization, neo-globalization. Wonderful. Now, Mr. Pranay, can I have your views on re-globalization and the role of lawyers?
Yes, thank you, sir. It's always fascinating to hear Professor Nedumpara because he gives a lot of food for thought, and it's a privilege to be on the same panel as him. Just picking up on a couple of themes from what he discussed, and it would probably shed some light that on the role that lawyers have already played in the re-globalization or change structures of globalization that we are seeing today. Beginning with the bulwark of what was considered the symbol of globalization, which was the General Agreement on Trade and Tariffs, or the GATT, which was the emblematic representation of the Bretton Woods system, the treaty that led to the formation of the World Trade Organization much later, as Professor Nedumpara was talking about. And that legal agreement, which was obviously the element of lawyers involved in it, was very heavy. But they were lawyers not representing a global body of lawyers. They were lawyers that were primarily US lawyers who conceived in the reduction on barriers to trade, which would benefit at that point what were considered the capital exporting countries. So you had countries in Europe, you had the United States, the more influential powers of the time. And it's fascinating because I don't think these countries from that time, this is 1948, could have ever imagined in 2023 that they would not be the ones holding the strings on global politics. They would not be the ones having the most influential voices in international bodies, including the UN. And that, in fact, has led to these states realizing the banes of globalization themselves. So re-globalization has now become an attempt to make a more equitable structure out of what was an integration of global economies. And in that restructuring of a more equitable global system, lawyers are, of course, central in imagining those views. Let's take two examples. The first example is of investment treaty arbitration in Europe. For the longest time, Europeans and European countries were the ones who were capital exporting, and European countries were not the ones that were being sued in an investment treaty arbitration. Over the last 10 or 15 years, what has happened is that European companies have started suing European countries for very large sums of money in light of their regulations. And suddenly, these European countries realized something that capital importing countries in Africa, in Asia, have been saying for a very long time, that the investment treaty system is very imbalanced in favor of the investor. And now they have created, from the European community, the EC, and the European Union, they have created a treaty that terminates all intra-European Union bilateral investment treaties, essentially trying their best, and this is a very litigated sector at the moment, but they're trying their best to basically disavow a system that they created themselves, because they've realized that the structure of the globalized economy was not equitable. The second and almost converse of this is something that's been happening in Africa, where Africa has also terminated, and are going to terminate rather, their intra-African bilateral investment treaties and create a central system under the African Trade Agreement, which will have an investment protocol to determine disputes between African companies and African countries in foreign investments. And their approach has been to create treaties, and this is known as the Africanization of investment treaties. And India has been doing something very similar post-terminating its own investment treaties, is that they are making investment treaties which were initially only putting obligations on states. They are creating new world investment treaties that also have obligations on investors coming into the countries. These obligations could be something as basic as respecting the business regulations, the human rights, not engaging in corruption when investment is made. Things that you would imagine would be pretty uncontroversial, but it's funny to see that these were non-existent till this time. And obviously, lawyers have played an essential role in the redrafting of these structures and these investment treaties. And that's one element of where re-globalization and lawyers have been central in making these changes. The other really strong element is the structure of international law itself. Now, international law comes from, or at least some people believe, comes from this Westphalian system of sovereignty, which essentially means it's Eurocentric. The moralities that international law imposes is essentially European moralities. The human rights system, the expectation out of states, it is considered to be very Eurocentric. Those sort of, there's in fact an article in the statute of the International Court of Justice which talks about